Mr. Parliament, I know you were concerned about the passage of time. The court has had an opportunity over the lunch break to consider matters, and we do not need to hear you on the relevant person argument or the scintilla temporis estoppel argument.
That's very helpful. Thank you.
Yes, as far as the appellants are concerned, they will have an hour between them, which they can divide up as they wish. Thank you.
So just before the short adjournment, my Lord Sales put to me a point under the transitional provisions, paragraph 6, that 6.3 provides for part 5 of the new code not to apply to a subsisting agreement, not therefore making any particular reference to part 4, so that part 4 would apply. Have I correctly?
Yes, the point was the transitional provisions seem precisely to disapply Part 5, which seems to leave the rest of the new code in existence in relation to.
So the consequence of that, for the reasons I was going through this morning, is that if Part 4 is available, which it is to subsisting agreements, it's available to subsisting agreements. So they are a subsisting agreement. They can't renew under the Part 5 procedure. They have to go to the county court for that. But so far as Part 4 is available, that is now available to them as a subsisting agreement that can access the rights in the code. The problem that they have is that when you look at the way in which the code operates, you can only have conferral of new rights once at the beginning. They've already had that stage gone through. Their only rights as a subsisting agreement are to renewal. I mean, there may be other things. The exception to that is the fact that you might want to make a paragraph 20 application to bind a third party that you haven't made before. That might still be available. But conferral rights have been dealt with, and you're not to have the right to renew under Part 5. You only get the right to renew by going to the county court under the 54 Act. Does that answer your Lordship's question?
Yes, thank you.
Yes, thank you. So I make the submission, therefore, that it's really the transitional provisions which have created any perceived difficulty, and that's a separate reason for not construing the code as a way of resolving a difficulty created by the provisions. There's no reason within the code to change its apparent terms, and it would be contrary to principle to change them as a result of something arising out of the transitional provisions. And so I'd like to go on to consider, again with the facts of this case, or these cases in mind, what the consequences would be of making a change, because that's something else that my friend hasn't really considered as yet. And it raises some really quite startling issues, which in my submission my friend hasn't really addressed. Now, I start this part of my submissions by saying that the code is intended to apply to a startling number of different factual and legal situations that could arise. A bewildering number, in fact. And as a general point, therefore, neither we nor, with respect, the court has the policy tools available to be able to identify all the potential consequences of adopting the approach that's preferred by the appellants. And so one has to embark on this with a degree of caution. The best I can do is to take some points that arise out of the facts that are before the court and then see where that takes us. Now, the most striking feature of consequences is in the Compton Beauchamp case. Now, just a very high-level summary, the Compton Beauchamp case is a three-way situation with a landlord, Compton Beauchamp, an operator, Vodafone, and a whip who has no current status on the site at all, but who is coming to apply for new rights, brand new rights, to be conferred by the code. Now, what it says, therefore, and my friend's submission has to go this far, is that you don't just tune out the operator's own occupation, because on the facts of Compton Beauchamp, the operator in question, which is Cornerstone, doesn't have any occupation of the site. What he's saying is not the presence on the site of the operator seeking the conferral of the rights, but the presence on the site of another operator, namely Vodafone. So we need to be clear about this. The suggestion being made is that you clear away, for all purposes, all rights of any operator on site, not just the person seeking the conferral. Now, that has an immediate consequence. Sorry, just to say, they have to do that to be able to win on Compton Beauchamp, because...
But they might fail on Compton Beauchamp. I mean, there is the intermediate position possible.
Well, indeed. So, but on
You've
this...
got two targets, as it were, but you say the extreme one is, has its own problems.
That's right. So this is the extreme one. The suggestion being made, therefore, is that although one might think that the problem under paragraph 9 is with an operator who itself is occupying and is itself trying to get rights, the submission being made by my friend for the purpose of winning in Compton Beauchamp is that you also tune out another operator altogether, and his lease and his presence on the site, for the purpose purely of allowing the new man, Cornerstone, to make an application against the superior interest, that's Compton Beauchamp. Now, there's an immediate policy complication about all of that, because at the moment, under paragraph 9, one operator can apply against an occupying operator for code rights under the Act. And in particular, when one considers who that might be, there is a distinction factually between whips, who are the infrastructure providers, and operators who are the network operators, MNOs in the jargon. And one could quite easily imagine the desire of an MNO, that is an actual mobile phone operator, to require some kind of rights from a whip. Now, the logic of my friend's conclusion, in order for him to succeed on Compton Beauchamp, is that you actually have to rule out the whip's occupation and proceed against the landlord.
If you're the MNO.
If you're the MNO. Which is an extraordinary submission to make, for the simple reason that if you follow it one step further, the landlord grants code rights to the MNO. How are those supposed to work alongside the rights that already exist, in fact, of the whip? Indeed, it goes that stage further. How on earth, in a case where the whip has some kind of legal title, how on earth is the landlord supposed to confer anything worthy of the name that entitles the operator to go into occupation of a piece of land which is already given away to the whip? It makes no sense. Now, for these purposes, or the purpose of this part of my argument, it's not the lack of sense that's so troubling, it's the policy. there is a distinct policy change there in that right now an operator can apply against another operator for rights. And my friend is saying that that should be abolished by this court, essentially. Now, that simply cannot be done. There's again, sticking with the Compton Beauchamp situation, there's a raft of sort of separate considerations which shows that this cannot have been intended by the code. As regards Vodaphone's position, now if you're the new boy on the site, you're the cornerstone in this example, and you're seeking to get rights conferred upon you by the superior landlord, the freeholder, the person most nearly concerned with that is Vodafone, because Vodafone is actually on site and is in occupation. But there is no provision for Vodafone or for Vodafone's interest to be taken account of. In particular, suppose, I don't know whether this is true of Vodafone and Cornerstone, because we know nothing about Vodafone on the facts of this case, but suppose the two rights are conflicting. Vodafone doesn't want it, doesn't want to have its apparatus interfered with, or doesn't want another signal too close to its apparatus, or for some other reason doesn't want to share its site with somebody else. Now, how does one deal with that as a matter of conferment of the relevant rights? The answer is that the procedure under the code doesn't, in fact, allow for these three-way disputes. And it doesn't allow for them to be regularized in this way.
Wouldn't you apply against Vodafone under 10.4?
Exactly. I was going to say that what there is binding, but that is not about conferral. So what is the right that Cornerstone would want in relation to this site? Is it a right to use Vodafone's apparatus? Or is that part of what the intention is? If so, how can you possibly do that if you don't bring Vodafone to court at the same time on the issue of conferral? Now, one contrasts that with, as it were, the lack of any such consequence on the way that we are putting the case. What we say should happen is that Cornerstone comes new to the site and takes the site as he finds it. As it happens, Vodafone is on site at the moment, and so under paragraph 9, it needs to deal with Vodafone. On the facts we know about, Vodafone's title is both precarious and also deficient in that it doesn't seem to have a right of access. But rights of access to apparatus are, or can be, code rights. I've forgotten the exact paragraph now, but an access to your apparatus is a code right. And if you need to join in Compton Beauchamp to confer access rights, you can do that. So you'd need to make one application against Compton Beauchamp for the access right, and that is in respect of land over which Compton Beauchamp is the occupier. I think the facts are that it's about a mile from the road to this site. And then you make a separate application against Vodafone because Vodafone is the occupier, and you get whatever rights emerge from that process. And then you bind Compton Beauchamp to your rights against Vodafone. That is a relatively straightforward way of dealing with the position. But that is That is not what they want to do. They've decided to forget about Vodafone, even though it has a presence on the site, and even though that presence remains unresolved, and go straight to Compton Beauchamp to grant all material rights, which will inevitably have some kind of effect on Vodafone as yet unknown. Now, between the two situations, we suggest as policy the court should stick with the way in which the code addresses it rather than try to fix it in some other way.
How can Vodafone apply for access rights?
Vodafone can apply for access rights by a new application under the new code, for new rights, therefore. I'm not quite sure offhand what the existing position is, so I don't want to be held to, I don't want to mislead the court in any way, but just looking at it theoretically, suppose there were no access rights, or they'd lost the access rights for some reason, then there would be a possibility for them as an operator to apply against the occupier where the road is, which on this example would be Compton Beauchamp, and you can get the access over the road that Compton Beauchamp occupy.
Yes, so the hypothesis that there is no access right, there is no occupation on your approach over that access road, and therefore paragraph 9 is, on your approach isn't a hurdle.
It's not a hurdle. Exactly.
Compton Beauchamp could confer it. If they didn't, you could go to the tribunal under paragraph 20.
That's right.
Yes.
So brand new rights are all available, and this is brand new rights in respect of areas that are not occupied by Vodafone. So the access route one assumes on this hypothesis is the mile-long driveway up to this particular site.
On neighbouring land which Vodafone is not in occupation.
Precisely, it's neighbouring land, and you can then get all the rights that you need to be able to use the particular site selected. So I invite the court to reject the suggestion that such a major inroad should be made into the way in which paragraph 9 operates by denying operators the opportunity to make applications amongst themselves for code rights where they are occupiers. The second sort of consequential area one can consider is under the Ashlock facts. We know, and the Court of Appeal indeed has told us, that Ashlock has to go to the 54 Act for renewal. But what it's saying is that it has the right in the alternative to make some kind of paragraph 20 application. And in its case, even though it is the relevant operator in occupation. Now, the first point is that there's no need to even consider Ashlock's position because Ashlock has the right to go for a renewal under the 54 Act. There's no difficulty with that at all. The particular point, though, that emerges is that the suggestion would be that there is still some kind of dual protection available to Ashlock. It can apply under the 54 Act, and it can also apply for something, anyway, under paragraph 20. That's its thesis. And we say that that runs completely contrary to the way in which the code and the transitional provisions are set up, which is that if you want some new rights, which is the hypothesis my friend puts forward, those new rights must be obtained from the occupier, and you simply can't do that. The practical effect of that situation on my argument is simply that they are limited to the 54 Act rights. And so the rhetorical question is, well, what's the harm in that? Why does one need to do anything to interpret the code to prevent that situation from arising?
As I understand it, you say that, though, that that's the case, do you, even if one were to read paragraph 9 as not preventing an agreement between the operator and somebody else, if the operator is the occupier?
Yes. Yes. The point being that once you have an agreement, the way in which the whole scheme works, once you have an agreement, your further rights are governed by Part 5. Or in the case of a company like Ashlock, the Claimant in Ashlock, Cornerstone, is governed by the 54 Act. So if you're looking at fresh rights, you've got to fulfil the requirement of the code for obtaining fresh rights. Now, in Ashlock's situation, or in the situation in Ashlock, the only way you can do that is to move off-site, give occupation back to somebody, and then make an application against that person, which is fine. You can, that is what is permitted by the code, applications by operators against occupiers, as a fresh person coming to the site, as it were. Insofar as Part 5 is concerned, though, you're not supposed to have any protection against in respect of Part 5. You're supposed to go under the 54 Act. So if one were to adjust the meaning of paragraph 9 to allow an operator on site the advantage of forgetting about its own occupation, you are doing something which is completely contrary to the express provision of the transitional provisions. I mean, this is really the point of the second issue in Ashlock, which was decided by the Court of Appeal in our favour, that it's contrary to the transitional provisions. But I'm reading that into the policy point about whether this court should interfere with the meaning and operation of the code. We say the code and the transitional provisions together have told you what's supposed to happen. It would be quite wrong as a matter of principle and policy to then allow something else to happen in the case of Cornerstone in the Ashlock facts, because that undermines the policy that Parliament has in fact set. And again, from our point of view, looking at the lack of consequence on the way we say it works, we say there's no problem in Ashlock anyway, because they've always got their 54 Act rights. They don't need to go under anything else, and that's all they need.
I thought you said it didn't. That if paragraph 9 were interpreted in the way suggested, it wouldn't help them, I thought you were saying. But I misunderstood that, so it would help them. I thought your contention was that as a result of the transitional provisions, the only route open anyway
Yes.
was to go under the 1954 Act.
That's if you want to stay on site.
Yeah.
So if you want to stay on site, what you need is a renewal right. And the only renewal right you've got is under the 54 Act.
And you're saying, therefore, that it wouldn't assist the operator even if they succeed on the point that paragraph 9 is not to be interpreted as preventing an operator from making an agreement with somebody else if they're in occupation.
Yes.
Thank you. Yeah.
I'm sorry to go back to the point I raised before, the short adjournment. I'm still trying to see how your argument works here. Within the code, as I understand your argument, you say any renewal or variation of the original code agreement has to be carried out within Part 5. And that, as I understand, you say is an indication that paragraph 9 really is focusing on occupation, including an operator who may be in occupation, because otherwise, you say, people can, in effect, bypass Part 5. They can try and sort things out during the life of the code agreement.
It's the dual protection comes back in again when it was supposed to be eradicated.
So I think I followed the pattern of that argument. Why isn't it the same pattern of argument in relation to the 1954 Act transitional provision? Because at some points in your submissions, you do seem to come quite close to that and say, well, if you've got a subsisting agreement under the 1954 Act, that's how you renew the code rights. And it can't be right to use paragraph 20 to, if you like, bypass that renewal regime.
That's my general point that I hope to have made in relation to the way in which the scheme operates,
right,
which is that you have Part 2, which for practical purposes deals with initial rights, conferral of rights, subject to what may be a long tail to make sure that you bind everybody that you need to bind.
Yes.
But that is the only right available for conferral. Once you are in a position of conferred rights, i.e. somebody with a subsisting agreement, then you are bound by Part 5. What you don't have is the opportunity to go back to Part 2, unless, of course, you fulfill all the requirements that would enable that to be successful, which, in the case of Part 2, means moving out, taking all your kit with you, putting somebody else in occupation, and then applying against them.
Right. But so far as the new code is concerned, don't you need your interpretation of paragraph 9 in order to protect or in order to ensure that the only possibility of renewal occurs under Part 5? Because if applications can be made during the life of the original code agreement, then that gives the possibility for seeking conferral of new rights on the operator during the course of the code agreement.
I may have the logic wrong, and that's always a serious possibility.
It's more likely I have.
My understanding of the way it works is that if Part 2 limits your conferral rights, then you have to get them conferred in accordance with Part 2. Once you have rights, then you're looking at renewal rights, which may be Part 5 or it may be 54.
Right.
You don't re-access Part 2 rights at any stage in that process. So when you have a subsisting agreement that is carried forward into the new code, the consequence of that is that conferral is still a dead issue. You're looking only at renewal and modification for the future.
But isn't conferral a dead issue because of what you say about paragraph 9, or is it a dead issue for other reasons?
My submission, and I'm sorry if I haven't underscored this enough, but my submission is that the way in which the procedure works means that conferral is a dead issue once it's done anyway, quite apart from anything to do with this narrower point about operators in occupation.
Which won't always apply.
Which won't always apply.
So one could have a case where the operator isn't in occupation, but your submission is that that once you're into the agreement, you're in that process anyway.
Precisely.
Yes.
Precisely.
So I think the answer to Lord Sales's question is yes. That there only are two, on your approach, there only are two possibilities of renewal: Part 5 and the 1954 Act, and you have to interpret paragraph 9 narrowly to maintain that policy intention. I think that's the point, Lord Sales.
I thought you were saying you don't have to interpret paragraph 9 narrowly in order to maintain that.
Yeah, that's what I'm confused about.
I don't know whether it's narrow or wide. I just ask it to be interpreted in the form in which it is stated.
The protection of those two means as being the only manner of renewal is consistent with your approach to paragraph 9. I'll put it that way.
Yes, that is certainly consistent with it. And
It's consistent, but it doesn't depend on it, as I understand it, because you're saying that even if the operator was not in situ, paragraph 9 wouldn't help them.
well, yes, but my point is looking at the inconsistency of their position. Because if they are saying that you can apply again, even though you're an operator in situ, they are saying there's some other means in which they can confer new rights on them, even though they've got rights already.
But if you, I mean, is it the choice of the operator who has a subsisting agreement which is covered by the 1954 Act? Is it their choice whether to renew that under the 54 Act or go under Part 5, or remind me, does the regime dictate which it is?
This that we were looking at earlier, paragraph 6 of the transitional provisions on page 1878, is the provision which says, and this is the result of 6.3, Part 5 of the new code does not apply to a subsisting agreement that is a lease of land if, basically, you can go for 54 Act renewal.
But then if you have a 54 Act agreement, I'm not sure how far you then have any of the rights that somebody would have under Part 5. What do you do if you've got a 1954 Act agreement, but you want to do something that is permitted under Part 5?
You have no rights under Part 5. That's what it's saying, is Part 5 doesn't apply to that kind of subsisting agreement.
So you say they have no rights under Part 5 and they have no rights under Part 4 either?
Yes, exactly. So, but what they do have is the right to renew their lease. The policy underpinning that being that they should be held to their bargain, which was that they had the right to renew a lease. They chose to do it in that way, and they should be held to do it that way. So they can renew their lease under the 54 Act, but they don't get access to any of the new code rights under Part 5.
But if they choose not to renew their lease,
Oh, that's fine. They can choose not to renew their lease.
and then they do have Part 5 rights?
No. It's reading paragraph 6.3 again. Part 5 of the new code does not apply to a subsisting agreement which can be renewed under 54. Doesn't apply.
But where the primary purpose of the lease isn't to grant code rights.
That's right. That's right. And there's an agreement. My friend suggests that perhaps we could look at 2 to understand it. Part 5 of the new code, that is 6.2, Part 5 of the new code does not apply to a subsisting agreement if that agreement is a lease of land, if it's a lease to which Part 2 applies, and there is an agreement, and there's no agreement under Section 38. I'm sorry, yes, I may have got the wrong, sorry.
I think
I think it's 6.2 you should be looking at.
I'm sorry, I should have been looking at 2, and maybe I've confused my lady with the wrong one. But yes, it's paragraph 2, which is the relevant paragraph for these purposes. Part 5 of the new code does not apply to a subsisting agreement that's a lease of land if you can renew it under 54 Act. So that means there's nothing in Part 5 for you. You chose to organise yourself as a lease with 54 Act rights of renewal, and the transitional provisions say you are stuck with those. So that's the Ashlock. Well, just thinking about consequences, that's the Ashlock position. On Tower is in a sense a simpler position, because you have you had an agreement that was not a subsisting agreement, and therefore the operator was not entitled to access any part of the code as a person with an existing agreement. That means that they cannot access Part 5, or indeed anything else that might exist, and they're left with no code protection of any description. And the reason, or the policy reason behind that, seems to be that your rights are just too precarious to warrant protection under the new code.
But under your argument, they can't either apply under paragraph 20.
Correct, because the new code doesn't apply. The only way in which they, sorry, I should say that, the only way in which, I make the distinction between an agreement which comes under the new code and the position which would exist if you had no agreement. So just follow that through. If it's an agreement under the code, you're not in the code at all if you're not a subsisting agreement. So the only thing you can do is whatever anybody can do who is outside the code, and that is to make an application against an occupier for the conferral of rights. And the logical consequence on the facts of OnTower is, as my friend explained them, is indeed that means they have to move off and move back on again. But the reason that consequence follows is because they've been denied the protection afforded to other subsisting agreements, other agreements, by the transitional provisions. And that, we suggest, is absolutely the wrong reason to be tinkering with the operation of the code.
And that's partly, as I understand it, because there's no written agreement. That's why they're not subsisting agreements.
Yes.
So you might say that if Parliament had enacted for certain subsisting agreements not to be in writing, there wouldn't be this problem.
Yes, yeah. It's always
Sorry, I may have put that the wrong way round, but what I mean to say is, given that there's a clear policy that the subsisting agreements have to be in writing, people whose subsisting agreements are not in writing are clearly outside that particular provision.
That certainly seems to be one aspect. The need to move over to a system of greater formality was certainly part of the policy thinking, hence the need to put it all in a document, that's paragraph 11, and indeed for the document to say how long the rights are exercisable. So in one piece of paper you can see how long you've got, and then you can start conveniently operating Part 5 modification and renewal procedures when the time falls in.
But you're worse off than you would have been under the old code, is that right?
Yes, I haven't really considered what in fact the situation would have been if they had tried to make an application under the old code. The position would be this. Under the old, just very high level, under the old code, there was no right of renewal at all. So what happens is that the landlord is happy to keep a person on site until he wants to get rid of them, at which point he makes an application for the apparatus to be removed. When that application is made by the landlord, and it's entirely at the landlord's initiative, the operator has the right to serve a counter notice explaining all the steps he's going to take in order to resist the right to lose his apparatus or to take his apparatus. And they could include the an application for new code rights. under the old code. But the old code had the same provision, which is that the only person from whom you can obtain new rights under the old code is the occupier. So you'd run into the same problem under the old code as you run into under this code. So it's difficult to see that there's any particular difference between the two. It all depends whether under the old code and under the new code the position would apply. Now there's one refinement to that, of course, which is that under the old code there was a provision that allowed the court to consider an application for new code rights on the footing that there's some hypothetical moving of the apparatus moving away and moving back again. And it says that in fact you assume that that has taken place and the court can continue as if it doesn't. So to that extent, you might be better off. But there's no case that I'm aware of anyway under the old code of how that actually worked in practice. And so I wouldn't leap to concede that On Tower is worse off now than it would otherwise have been. I would go so far as to recognise that that is possible, but how it would have worked itself out under the old code, there's nothing that I'm aware of that really guides us in that respect.
But you don't accept that the idea that because they don't have a subsisting agreement because it's not in writing, but they do have, they are an occupier for the purposes of paragraph 9, doesn't create the kind of absurdity that you accepted is created in paragraphs 26 and 27 that says, well, in these circumstances you have to look at occupier as meaning something different and not including this unfortunate operator who's in this fix.
No, because one of the other difficulties under the old code is that it had to be in writing as well. So you'd run into the oral, if you're an oral agreement problem, there had to be some kind of writing. The question is, would that have applied to a situation as On Tower has found itself in?
And what procedure applies to somebody in their situation for the landowner who wants to get the equipment removed?
That's the Part 6 procedure.
Yeah. And that does apply, does it, under the new code? Or no,
well,
it doesn't if it's not a subsisting agreement.
That's right. It doesn't apply if it's not an agreement that's brought within the new code.
So what does apply? What does govern that?
General law. The old code's gone, so you're not interested in that. The new code doesn't apply because you're told that it doesn't apply. So the landlord has whatever rights he has to be able to get rid of equipment that is on his land.
But has the equipment now become part of the land? We can't rely on paragraph 100 and whatever it was to say that the property is not part of the land. Who then owns the equipment? Or was there equivalent?
Well, it'll be an issue. Well,
you'd expect the normal law fixtures to apply on your approach?
Yes. Yes.
I think that must be the logic of your position.
Yes, it becomes part of the land while it is a fixture, but
you might have a right as the superior landlord to require someone that has brought on items which have been made fixtures to remove them.
Yes, and I was also thinking from the tenant's point of view that there's likely to be some kind of right that enables them to take it away at the end of their tenancy. I suppose it all depends whether it is a tenancy and what the terms of the agreement are. Mm-hmm. But at all events, my submission is that what is being impressed on the court by my friends is not a simple tweak to resolve an apparent difficulty. It's something which has a very far-reaching effect, which is, moreover, contrary to the scheme as laid out by Parliament, by both the Code and the transitional provisions. And without knowing the full implications of what such a change would be, it is inappropriate even to consider making that kind of interpretative adjustment. I'm anxious about the time, even with the points that my Lord Hodge has told me I don't need to deal with. I think what I do need to deal with, therefore, is the secondary argument of Mr. McGee. So his first argument is that you tune out all operators and their kit and their...
The second argument is control is occupation by right.
That's right.
Yes.
And he puts that on the basis of the Grayson line of cases, and in particular the ability of the court to understand from any particular circumstances where occupation becomes an issue, what are the requirements that need to be proved in order to establish occupation or non-occupation. And so from that very general statement, he says that one of the issues on the facts of or on the terms of the code is that there should be some kind of right of control as well as physical presence on site. Now, the high point, as we understand it, the high point of his case is the Woodcock decision. And I say that because there is no other case which deals with an issue about occupation and how you interpret it for a particular purpose, which even begins to suggest that the right to occupy is part of the mix. The Woodcock case, which is tab 46, is and
2969
is sorry,
2969.
Thank you. 2969. That is the case where a claim was made to access an electricity supply by a trespasser who indeed had committed a criminal offence by effecting forcible entry of the premises. And that is the case in which there's a number of arguments that are set out by counsel for the defendants, and they start at the bottom of 985. That's the report of 985, and the page in the bundle is 2971. Counsel for the defence submitted the word occupier meant lawful occupier. He drew my attention to the duty of electricity authorities to give and continue to give a supply of electricity. And he submitted that if, after having given the supply, an authority subsequently discovered that an applicant was not a lawful occupier, then there was no duty on the authority to continue the supply. He drew my attention to a number of sections of the Act, which in his submission supported the construction that occupier meant lawful occupier. So the submission was tied to the words of the Act that shows that there was a lawful occupier as part of the process. And then just dropping down to below C, he also submitted that if the occupation constituted a criminal or quasi-criminal offence, then it was impossible for such an occupier to acquire any legal rights. He relied for that on Glamorgan and Carter. Therefore, he said, in construing the word occupier, that word must mean a lawful occupier to the exclusion of an unlawful occupier. And then he made a further submission as to how you should construe statutes so as to give legal rights to wrongdoers unless the words of the statute impel that construction. And then on the next page, just after letter B, finally, counsel for the defendant submits that a person seeking an equitable remedy should make a full and frank disclosure of all the relevant facts, which he said they hadn't. And the decision of Mr. Justice Dunn is, after D on this page, in construing section 27.1, I'm not concerned with the question of whether an electricity authority is under a duty to supply electricity to other classes of occupiers. I'm simply concerned with whether the word occupier is apt to include the plaintiffs. I accept the submissions of counsel for the defendants. In my judgment, whether or not the plaintiffs committed a criminal offence, they never gained possession of the premises, as that word is understood in our law, by reason of the circumstances of their entry. Such an entry was unlawful, and the word occupier in section 27.1 does not, in my judgment, include a person whose original entry upon the premises was unlawful and forcible, and so on. And maybe other occupiers could get electricity, but not this one. Now that is rather a long way from saying that, as a general point of consideration, one might like to look at the rights of the occupier alongside the physical fact of occupation. And there's nothing equivalent in our case to the kind of statutory background that underpinned the decision in Woodcock. So we say in a case like this, and for present purposes, I will stand on my statement of case where we set out our submissions in relation to this aspect of the case. We say for present purposes, there is no good authority which suggests that the secondary argument has any bearing on the matter at all. Occupation for these purposes is about actual occupation rather than the right to occupy. And the one point I should take up is the particular point that my friend made under paragraph 105, which is at page 1874. This is in relation to the cascade of land ownership. Sorry, land occupation. There's the 105 explains who the occupier is in certain circumstances, and the overriding one is number one. References in this code to an occupier are to the occupier of the land for the time being. And we've seen that the occupier can be the occupier of this land. It could be the occupier of neighbouring land in certain places, like in paragraph 38. Occupier has a meaning across the board for the purposes of this code, not confined to the particular situation of operators in the position like my friend is in at the moment. And then there are some provisions about occupation in relation to footpaths and streets and so on. And then 5 says, subparagraph 6 applies in relation to land which is unoccupied and is not a street, and 6 is that where you've got unoccupied land, therefore, references in this code to an occupier are to the person, if any, who for the time being exercises powers of management or control over the land, or if there's no person within paragraph A, to every person whose interest in the land would be prejudicially affected by the exercise of a code right in relation to the land. So the second stage, though, my friend, I think, sought to describe or characterise the second stage, which is 6A, the person, if any, who for the time being exercises powers of management or control over the land, as involving some right. Whereas it doesn't say anything about right. You don't move from occupied land with or without right to unoccupied, where rights suddenly come into effect. No, they don't. At the second stage, it's just another factual question whether or not somebody is, for the time being, exercising powers of management or control over the land.
But it doesn't say, for the time being, is managing or controlling. It says exercise powers of management.
Yes.
How can there be powers which are not legal powers?
Well, my suggestion is that is just factual. That is a factual question, and I'm making that submission because I support Lord Justice Lewison's conclusion on this point, that the first two stages are both factual. One is who's in occupation. Two is what are the powers of management that are being exercised.
I mean, in a sense, that is factual. Factually, are there legal powers of management which are then being exercised?
Yes. Well, I think Lord Justice Lewison came to the opposite conclusion, and I would...
which is the reference, so we can look it up?
It probably doesn't affect the outcome, does it, whether stage 2 is legal or factual?
Yes.
I mean, your point is that stage 1 is factual anyway, and stage 3 is undoubtedly legal.
Yeah.
In a way, it doesn't matter whether stage 2 is legal or factual. I mean,
Yeah.
But you say it means the same as if it read who is, for the time being, managing or controlling the land.
Yes. It's paragraph 54 of Compton Beauchamp is Lord Justice Lewison's comments on that. So almost on cue. I'll leave my submissions there if I may. The only yes, I've agreed. The only point that I would make in closing is that we were promised. Sorry, I don't mean that pejoratively. We were understanding that we were going to get a document from my friend Mr. McGee as to his sort of closing position, as it were. That piece of submission of his submissions that he had to rush rather, and none of us got a good note of it. The document has arrived, but it only reached me at 20 to 2.
Well, I'm very content that if you want to put in a short written response to that document within the next 7 days, that you do so.
I'm grateful, my Lord. That's all.
Would that meet your need?
Certainly, Lord. Thank you.
Thank you very much.
Lord, can I say at the outset, while I recall, that as I understand it, everyone is agreed to defer submissions as to costs until after judgment, and that's an indication, as I understand it, we have to set out now. So we're doing that, and I think my learned friends agree with that. Yes.
I wouldn't expect to be addressed. This court would not expect to be addressed on costs at an oral hearing. Yes, of course.
I understand there's a rule saying that we need to say this during the oral hearing. So I'm doing so. It was new to me as well. But learned from Mr. Oliver Bradley Gardner, who does nothing but read the rules of the Supreme Court, tells me that that's what it says. The second thing I need to do is to correct an error that I made in my opening submissions. I don't think it affects the matter, but let me do so for completeness. And it concerned the position of a 54 Act protected tenant who has a subsisting agreement. So as at 28 December 2017, I said that that was treated as an agreement under Part 2. That is correct. I said that Part 5 did not apply to such a person. That's correct. My learned friend has made that point today. But I also said that such a tenant had all the other characteristics of a Part 5 agreement. That's not right. It does have the characteristics in 10, 12 and 14. That is, applications to successors in title, 12, lawful use, and 14, no need to register. But it does not have the benefit of the prohibition on provisions preventing assignment or the automatic right to upgrade and share under paragraph 16 and 17. Paragraph 5(1) of the transitional provisions say so, page 1878. So I don't think it affects matters, but I mention it. Can I also deal very briefly with 4 points that my learned friend Mr. Pymont made, which we say are not accurate as a matter of law. Again, I'm going to deal with them very quickly, if I may, because I don't think they actually affect the substance of the matter. The first was a point that he spent quite a long time yesterday on, where he said that if one was looking at the occupier of land conferring rights by agreement under paragraph 9, the occupier could not confer more rights than it in fact had. That was the point. In my submission, that's not right. If he were right, there would be no purpose in paragraph 10(4). Interestingly, that very point, which is that in order to confer rights, you need to have a right to do so, was a point that was argued in the Court of Appeal by Cornerstone in the Compton Court of Appeal and was rejected by the Court of Appeal. And the analysis of Lord Justice Lewison in the Compton Court of Appeal, paragraphs 28 to 30, which is pages 214 to 215 of the bundle. Again, I'm not suggesting your lordships necessarily look at it now. Makes that position quite clear. I'm obviously happy to go to it if you'd like me to. The point is made there, for example, that although it might seem surprising, as a matter of law, one can even grant a lease without having any interest in the land. And there's a House of Lords, is it House of Lords or Supreme Court? House of Lords case saying that, Bruton and London and Quadrant Housing. And that's the starting point for Lord Justice Lewison's analysis there. The idea is that the person who is the occupier confers the rights. That can be for 10 years or 15 years or whatever, even if the occupier has only got a 2-year agreement. But in order for that to be binding on the freeholder, an application would either the freeholder needs to agree under paragraph 10(4), alternatively an application has got to be made under paragraph 20 against the freeholder for it to bind him. That's the way the scheme of the Act works. It's not about right to grant. That's the first point. The second point is my learned friend said that paragraph 30, and if I can just remind you of that, that is page 1833 of the bundle, which provides for the automatic continuation of rights, works in the same way as Part 2 of the Landlord and Tenant Act 1954 does. In my submission, it doesn't. It is right that in order to have continuation rights under Part 2 of the Landlord and Tenant Act 54, at the contractual term date, you need to be in occupation carrying on a business. But if you're in occupation carrying on a business at the contractual term date, then there is a continuation tenancy under the 54 Act, which continues even if you then cease to be in occupation. It doesn't disappear the moment you go out of occupation. It is brought to an end, assuming it continues post the contractual term date, if it's a fixed-term tenancy by the landlord or the tenant on 3 months' notice, at least 3 months' notice. That's Section 24.3 and Section 27.2 of the Act. If it's a periodic tenancy, which is brought to an end by the landlord serving a Section 25 notice, which has to give 6 to 12 months' notice, then it continues until the expiry of that notice. Section 25.1 says so. If there's then an application for a new tenancy, it continues until 3 months after the final disposal of that application under Section 64. So, again, I'm not sure it necessarily affects the outcome, but it's not right that there is it's not right that under the 54 Act rights disappear the moment there's no longer occupation. So for our part, we prefer the, if you like, the interpolation solution that I suggested to my Lady Rose on, I think, the first day, rather than the solution that suggests that when one ceases to exercise code rights, then at that point the agreement no longer continues. That was the second.
I'm not sure the removal of equipment would work otherwise on his approach.
Indeed. The third error, with greatest respect to my learned friend, we say he made was this afternoon in relation to the removal of equipment. He said, as I understood him, that Part 6 had no application at all. That's the right to removal and the right to require removal, and the matter was left to the common law if the operator had no rights in the first place. That's not right. If one looks at paragraph 37.2, which is in page 1838, if I could just take to that. Yes? That's one, yeah. So there are paragraph 37.1 says that one of two conditions have to be satisfied in order for a right to removal to arise. If you have no rights and have never had any rights, you fulfill the first condition. You don't need to have had code rights which come to an end. The fourth error, we say, was made, and again, I'm not sure any of these are fundamental, is in relation to the fascinating question of whether a fence is part of ECA. We say it is part of ECA. If your Ladyship would go to page 1814, which is the definition of ECA. And it's paragraph 5.1d, other structures or things designed or adapted for use in connection with the provision of an electronic communications network. The purpose of the fence is in connection with the provision of the electronic communications network. I'm sure it's identical to fences that one sees in other places, but so are the screws, the bolts, and the wires that keep together the masts. It doesn't have to be special. So those are those four matters. As I say, none of them, I think, are fundamental to the appeal. Can I turn to, in turn, and very quickly, going through the list of problems that we say would occur if it was right that an operator was considered, was capable of being considered to be in occupation, so that it couldn't obtain rights under paragraph 29. The first is, I'm going to deal with them not in the order that my learned friend dealt with them, but the order in which I dealt with them in my submissions. The first then is paragraph 26. And my learned friend accepts that it's a possible outcome that the operator may be in occupation, and he also accepts that it's possible that the purpose of the application under paragraph 26 may be for the conferral of rights. Indeed, it goes rather further than that. In the typical case, the operator will be in occupation, and indeed the primary purpose of an application under 26 for interim rights was to lead to full rights. And I took your Ladyship to 26.7b that showed that to the explanatory notes 422 as well. So that's the clear and obvious case. My learned friend accepts that the solution to the dilemma proposed by the Court of Appeal in the Compton case does not work. 26(4)(b, what he calls the deeming provision, he accepts does not work in that situation. Instead, he suggests that in this case, we should read the word occupier differently. He makes two suggestions. One, if interim rights are granted against the teeth of opposition by the landlord, then the landlord is still to be treated as in occupation. Or secondly, if the landlord consents, then that occupation is a reflection of the landlord's own right to occupy. Neither of those work. If the landlord consents to occupation by another, by the operator is not a caretaker. He's not one of the landlord's children. It's a person, an independent person who has acquired rights and is occupying on his own behalf. It doesn't work on his test of occupation. Neither, if rights are granted in the teeth of opposition by the landlord, they are still rights granted to the operator who has a right to them. It's completely contrary to his test of occupation. So on this part, he has to accept that paragraph 9 on his case has occupation has one meaning, but on paragraph 26 it has a different meaning. Can I move on to paragraph 27? He says this is limited to cases of making a person bound by rights rather than conferring rights. Not so, because paragraph 27(2) makes it crystal clear, as I think my Lady Rose said during argument, it also includes conferring rights on the operator. Now, in this case, he did rely on the deeming provision. The deeming provision, of course, applies only to the grant of temporary rights under paragraph 27. It has absolutely no application to the paragraph 20 application that follows on from that. It can't work. It's expressed in precisely the same terms as the one under 26(4)(b). Why is it no application under 26(4)(b), but suddenly does have application under 27(4)(b)? Of course, if it did work to make the operator not the occupier, which, as your lordships know, we say is not the purpose of it at all. It's to bring in the special characteristics of code agreements. But if it had that purpose, then so too would paragraph 22 solve the problem under paragraph 20. So far as moving on, the third point we relied on was paragraph 40, subparagraph 8. Learned friend says, I can work out a set of circumstances in which you can make a paragraph 23 application which doesn't cause a problem if the operator is treated in occupation. And that's if it's about binding a superior interest rather than conferring rights. But it includes circumstances in which rights are conferred. Paragraph 40 applies if paragraph 37 applies. Paragraph 37 we looked at, paragraphs 37(3), B and C, posit situations in which a operator had rights which continue under paragraph 30, which are then terminated by the court, and where there is a right of removal. And that's precisely the same situation in which paragraph 27 applies. Paragraph 27 and paragraph 37 apply in circumstances, and only in circumstances in which the landowner has a right of removal. And we know under paragraph 27 it includes conferring rights. So that explanation doesn't work. I'm going to keep moving on unless stopped. Paragraph 37(4) is the next one. And the short answer to this is, on my learned friend's case, it will sometimes work and sometimes won't work. And it seems completely unreal that this provision was intended to apply only in circumstances, and there will be such circumstances, in which the operator is not in occupation. Or sorry, in which the operator is not in occupation. But my learned friend's explanation to that is that this is a second case where occupied should have a different meaning from the meaning he says it has in paragraph 9. But as my Lord Sales, I think, pointed out in argument, paragraph 105 applies to both. So in my learned friend's case, occupier means three different things in different contexts. We say they mean precisely the same thing in every context. Additional rights during the term is my next heading. We say, and I dealt with this in opening, there is a distinction between variations of the agreement not involving additional rights and additional rights. So far as variations not involving additional rights is concerned, they can be done by agreement, paragraph 11 says so. But otherwise than by agreement, they can't be done until the end of the contractual term and an application is made under Part 5. That accords with the principle that people should stick to their bargains. If we've agreed to pay £5,000 a year to AP Wireless for a particular site, we can't come along 6 months later and say, can we just make it 4,000, please? But at the end of the 10-year contractual term, we can go and we can argue in court that really the market value should be 4,000, not 5,000. Different, though, for additional rights. There may well be circumstances in which, for unforeseeable reasons, the operator needs more code rights than it's got. It's got a right to put up one mast, it wants a right to put up another mast or a higher mast because technology's changed, because 6G, whatever that, has come out now, and that requires a mast twice as high. It then ought to have a right to go to court and seek that. And the answer to that is not paragraph 17, there's a right to upgrade, because that's a limited right. And the argument that occurs in many of these cases at first instance, and my learned friend Mr. Radley Gardner has got recent experience of this, is the question of whether the rights in the code agreement should go beyond those minimum rights. And there's a recent case called On Tower and Green, which is in the bundle, which contains a discussion of just this, where, interestingly, Mr. Claimant for AP Wireless was opposing the inclusion in the agreement of a provision that went beyond minimum upgrade rights. Why? So that if those rights were sought in the future, they could claim an additional sum for them. It's page, I'm not asking your lordships to go to it, 2464 to 2465 of the bundle, paragraphs 63 to 66 of On Green, On Tower and Green. And I've already indicated to your lordships at the outset the DCMS paper in January last year indicating that this was a very real problem for operators. The other point...
You say that if it is the case, as Mr. Piedmont says, that you can do variations that don't involve conferring additional rights, but you can't do variations which do involve conferring additional rights because of the occupier problem. You say that actually, according to policy, it should be the other way round.
Yes.
That you can understand a policy whereby you're not allowed during the term to make variations which don't confer additional rights because you're stuck with your bargain.
Yes.
But it doesn't make sense in policy terms to prevent the conferral of additional rights.
And of course, paragraph 20 is only about conferring additional rights. It doesn't allow any other variations. It's only about conferring additional rights. The other point to make here, of course, this is a problem where the operator is the occupier. Well, the operator is not the occupier. There is nothing to stop the operator making an application under paragraph 20. My learned friend would agree with that. Oh, sorry, I'm sorry. He wouldn't agree with that. On my case, it follows that the operator, if it's not an occupation, there is absolutely nothing to prevent it making an application under paragraph 20 during the term for additional rights. Now, I'm sorry to suggest that my learned friend says otherwise, because I'm reminded of what my learned friend says is it cannot do so because your only right to get those additional rights is under Part 5. Yeah, I'm sorry. I do apologise to my friend. What we say about that is this. Part 5 is dealing with what the position is at the end of the term. Paragraph 30 of Part 5 says, at the end of the contractual term, the agreement nevertheless continues. However, and then it deals with what then happens. And it says, the site provider can apply to terminate, or either party, by serving notice under paragraph 31, or either party can apply to change the terms of the agreement. And that includes various things, additional rights, modifications, new agreements. But that's dealing with that in that context. It's got to deal with all those things at that point. But that, in my submission, does not suggest in any way by implication that paragraph 20 is to be limited in some way. If it were to be limited in that way, it would have said so. My learned friend then says, well, look, but if that was so, it would be a terrible problem for us because you could make multiple applications and we would incur so much time and money and costs. And the short answer to that is that the court can make adverse costs orders if we make frivolous or hopeless applications. It can summarily dismiss those applications. In any event, the compensation that's payable can include the expenses incurred in the application. There's a reference to that in the recent Ontower and Green case at paragraph 69, which is page 2481. And furthermore, and this may just be worth turning up, provision we haven't looked at, page 1865, which is paragraph 84 of the code, setting out the power to order compensation when the agreement is imposed. And paragraph 84.2 includes the power of the court to order the payment of compensation for loss or damage, including power to order payment for expenses. So there's no practical difficulty caused by that.
You do get this rather odd position that once the agreement comes to an end and rolls forward under Part 5, then both parties can serve notice to change the agreement, to add new rights, to take away rights that exist, and vary the terms. But during the fixed term of the agreement, there's only one kind of court-imposed variation, namely the conferral of new rights, and it's very one-sided. There's no power for the landowner to apply to the court to remove a right.
Well, lady, that's precisely the position. The reason for that position, it might at first seem curious, but the reason for that is that the underlying policy is to assist infrastructure providers, mobile network operators, and other operators under the code fulfilling the government policy of the rollout of the telecommunications network. And in order to enable and assist that, it was felt that it was right that operators should be able to go to the court and say, we actually need more rights than we originally granted. We hadn't anticipated there was going to be this change in technology. Now, of course, at that point, it will always be open to the landowner to object to that, and the court will exercise its discretion. But the policy of the code, or those drafting the code, didn't foresee as a real difficulty the possibility that for some unforeseen reason during the course of the agreement that the landowner might have a good reason for seeking to bring the code rights to an end. That argument, it thought, would be one that would be raised at the outset when the original paragraph 20 application was made, and perhaps the operator was saying, well, I want a 20-year agreement here, and the landowner was saying, well, I don't know what I want to do with this land in 5 years' time. I think I might get planning permission for development of it as a residential estate. Please, can there only be a 5-year agreement? And then if you want to renew after that, you can renew under Part 5. So that in my submission was probably the thinking behind the fact that there was a right granted for additional code rights, not a right for the landowner to remove those. So I have dealt with additional rights during the term. The next conundrum was consensual Part 5 renewals. That is, the agreement continues under Part 5, and then the parties agree on a renewal, in which case the court does not have power to make an order under paragraph 34. And the question is, how does that work? No problem on my case, it's an agreement under Part 2. Malone and Friend needs to say that paragraph 34.8 applies. But in my submission, that's not easy to square with where 34.8 appears. Paragraph 34, I agree, doesn't set out, as 34.1 would suggest, simply the orders that the court may make, but it sets out what the court should do in making those orders and the consequence of those orders. That's what it's about, nothing more or less than that. It's not dealing with circumstances in which a consensual agreement is reached without an order from the court. If that was so, it would have been worded differently. And there's absolutely nothing in the fact that paragraph 22 is worded very slightly differently from paragraph 34.8. The next problem, which I don't... the next problem is this. Operators without 54 Act rights, they shouldn't be in a worse position than they were under the old code or the transitional provisions. Malone and Friend says, well, haven't really thought about that, but maybe they aren't in a worse position. Maybe under the old code, they would have suffered the same problem. Now, under the old code, there was no Part 5. There was no automatic continuance. So if Malone and Friend is right on that suggestion, under the old code, to get code rights, at every renewal, the operator would need to go out of occupation, make the application, wait for it to succeed, and then go back in again. On every time, every 5 years, or however long the agreement was before. That's not right. It's not the way to read the code, if only because of paragraph 21.5. And I also indicated in opening, it's clear on the transitional provisions, therefore, that you can have, the effect of the transitional provisions is to make subsisting applications under paragraph 21 of the old code the applications under paragraph 20 of the new code. So that is at least one instance where you've got operators in occupation who can get rights under paragraph 20 of the new code. Operators with 54 Act rights is the next heading. Malone Friend, I think, says, well, look at the transitional provisions. If you've got 54 Act rights, you don't have Part 5 renewal rights. Therefore, you can't have been intended to use Part 4 either. But it doesn't say so. The point of the transitional provisions was to make sure you don't have two continuation regimes, continuation under Part 5 and continuation under the 54 Act. But it didn't go any further than that. Malone Friend then says that this is a separate reason, the transitional provisions, why the Court of Appeal came to its conclusions, and that I'm not allowed to argue the contrary. In my submission, that's not so for two reasons. Firstly, it's not an independent reason that the Court of Appeal came to in Ashlaw. Its conclusion was, its reasoning was this, that the conclusion that an operator in occupation can't use paragraph 20 is a correct conclusion because otherwise it would conflict with the transitional provisions which preserve the 54 Act renewal procedure. It wasn't an independent reason, it just simply said it reinforced the reason that it had come to about the scope of paragraph 20. In any event, if a technical point is being taken, the answer to that technical point is that we did make this point in our permission to appeal application. Perhaps I should invite your lordships, your ladyship to look at this, page 712. We put in our application for permission to appeal. There was an objection to that, and then we put in a brief response to that objection at page 712, and paragraphs 2 to 4 deal with precisely that point. The other points to be made in relation to 54 Act rights is this. It is right that if there's a 54 Act tenancy, there's no right to renew under Part 5, and that the right of renewal under the 54 Act is retained. However, a tenant with the right of renewal under the 54 Act cannot be required to renew under that Act. It can decide to serve notice under Section 27 to bring its tenancy to an end. Or if an application for a new tenancy is made to the court, it can require it to be dismissed under Section 29(5) of the Act. Or if one gets to the stage where the court makes an order for the grant of a new tenancy, it can require that order to be revoked under Section 36(2). Why I asked rhetorically, in those circumstances, if that's what the tenant does, should it then have to move off the site before it can make an application under Part 4? Practical issues can be dealt with as a matter of discretion and a matter of case management. The other point that my learned friend didn't deal with, and I think he dealt with almost all my objections, but I don't think he dealt with this one, which is this. What happens if a 54 Act tenancy, as at 28th of December 17, which doesn't have Part 5 renewal rights, but does have 54 Act renewal rights, is renewed under the 54 Act? My learned friend says, well, it comes within Part 5. We agree it comes within Part 5, but it only comes within Part 5 if we're right, because it's an agreement made between the occupier, if the operator is the occupier, and the landowner. And it only comes within Part 5 if it falls within Part 2. It will be a paragraph 9 agreement on my case, but on my learned friend's case, it won't be a paragraph 9 agreement. And then the 54 Act renewed tenancy, which of course no longer, the moment it's granted, it's no longer within the 54 Act. If renewed after 28th December 17, that's what the Section 43(4) or something like that of the 54 Act says. But then it's not within Part 5 either. That can't be right. Blue-on-blue applications, that is rival operators, and my learned friend says, well, this is a huge, huge problem. It's not a practical problem at all. It rose in the very unusual situation of Ashlock, where Vodafone had no rights and was entirely content that Cornerstone sought those rights, and it would then get rights from Cornerstone. But the reality is the landlord won't grant those rights.
Did you say Ashlock? Is it not Compton? Compton Beauchamp.
Sorry, it's Compton. Yeah. Thank you, my lord. It's Compton, not Ashlock. The reality is that the landlord's not going to grant rights voluntarily to a rival operator, and won't be able to do so, because it won't be able to do so inconsistent with the rights that are already granted to the first operator. Also, if that rival operator goes to court and seeks an award under paragraph 20 and is granted rights, That won't terminate any existing rights to the first operator. And so for that reason, if not for other reasons, it's pretty unlikely that the court's going to make that award anyway. It won't bind the other operator. The court has a discretion. If it sees that there's one operator there and another rival operator is seeking rights, it's extremely unlikely it's going to do so. In reality, the position between operators is dealt with at the regulatory level. That's what governs the relationship between MNOs and WIPs. In any event, the position, the theoretical, and it's a highly theoretical position that my learned friend puts forward, is a position that obtains in any event in two cases. First, if two operators are competing for a vacant site. Or secondly, if there is an operator in situ who is not in occupation because it's got aerials on the roof or whatever. Can I come to what I headed the solution? And I want, if I may, as Lordships know, we say the approach to this is a purposive interpretation. And the point, as my Lord Legate, I think, identified yesterday, is simply whether this is something that this court can do or whether this is something that needs to be left to the legislature. In answer to some questions from my Lord Sales about, well, what about before the ECA is installed and operators are going in there for surveying or whatever, how precisely do we formulate what it is you leave out of account? We would put it this way, that in considering who is in occupation of land for the purposes of paragraph 105, one ignores any presence, physical presence or control of the operator in exercising the statutory purposes. And the statutory purposes is defined in paragraph 4. That is WIPs or MNOs. So if the reason that the operator is on site or doing acts of control in relation to that site is in connection with the statutory purposes, then that is to be ignored. And it's to be ignored for all purposes, whoever the operator is, whether it's the operator making the application or a third party. As your Ladyship knows, we regard paragraph 101, paragraph 108, and paragraph 100 as simply pointers to help us towards that conclusion. But the crux of the reasoning, if we're right, is the purposive construction. Finally, if I may, a word about the second argument. And the first point to be made about the second argument is, of course, it's possible that both the first and the second argument could be right. They're not alternatives. I only need to win in the, if I'm right, in the Compton case, I only need to win one of those arguments, but they could, in theory, both be correct. We say it doesn't make any sense for an application under paragraph 20 to be made against a squatter, who we know is then entitled under, I think it's paragraph 23, to consideration if an award is made, if an order is made conferring rights on the operator. The Woodcock case, of course, is just an illustration of that, in entirely different factual circumstances. The reason that one struggles to find cases of this is that normally occupation arises in a context in which there clearly is a right of control. Think about, for example, 54 Act renewals and the question of whether a tenant is in occupation. It clearly has a right of occupation. We say paragraph 105 is entirely consistent with this, and that the second element of the cascade requires a right of management and control. That's the reason it says exercising power of management and control. Last point, if I may, the Bridgewater case that I think my Lady Rose mentioned yesterday, referring to the point that the occupier is the person most easily identified. It's important to understand the context of this. Bridgewater is a case under the old code. So it's dealing with the amendments from the Telegraph Act to the old code. Under the Telegraph Act, one needed to show the agreement of the occupier, the lessee, and the freeholder. That was then limited to just the occupier. Instead of multiple consents, only the consent of the occupier was required. And that was because of those 3 people, the occupier was most easily identified. See, and I'm not going to invite your lordships to turn it up, but there's a report in 1982 preceding the old code, and it's page 1987, paragraphs 31 to 34 of that. I suppose the final point to make in relation to that is my learned friend, in the context of the great long discussion about whether an occupier needs to have a right to be able to grant, made the point repeatedly that in practice the operator wants to deal with the people who've got the right to grant. So in practice, it is not going to cause any difficulty whatsoever that you have to identify a person who's not simply physically there, but has the right to be there. Lord, I'm afraid that was a little longer than I anticipated, but unless I can assist.
Can I just ask a question? I'm not quite sure I noted it down correctly, but your formulation of what now classes as not being, the operator not being an occupation, is, I think you said, one ignores any physical presence or control of the operator in connection with the statutory purposes.
Yes.
Is that correct?
That is.
Is that the same as saying, more simply, that an operator cannot be treated as an occupier of the land in question?
Yes, one could simply say that. That would be another way of doing it.
Then you have to decide how you are going to work out who the occupier is, and your point is that you must ignore for that purpose any occupation by the operator.
Indeed, indeed. And there's no other counterfactual assumptions that one needs to make. One simply ignores the operator, and then one goes to the cascade in paragraph 105 and see if you come to it.
It's ignoring the applicant operator. I mean, that there could be someone on site who was an operator.
No, well,
You want to take it further, as I understand it.
Yeah, I say that under the code, operators are not treated as being in occupation if the reason for their occupation is because they're exercising the statutory purposes. If you had an operator who decided to land bank and decided to acquire a large area of farmland because it thought it might put a mast there, but if not, it applied for planning permission and build some houses there, or worse comes to worse, it puts some sheep there. But it had no plans now or in the foreseeable future to put a mast on there, and it was in control of that land, it wouldn't be in control of the land for the statutory purposes. That is, for the purpose of providing the operator's network, or for the purposes of providing an infrastructure system. And I think to answer my Lord Borough's point, that's why I formulated it in a slightly longer way.
Okay. The other question I had, if I may, the Cornerstone situation, the three-party situation.
Yeah.
I think Mr. Claimant was saying that there was a clear policy that you would, in that sort of situation, want to allow one operator to get code rights from the other operator, that is Vodafone. You wish to actually allow them to decide whether code rights should be conferred on Cornerstone.
I don't know whether that's what he did say, but if so, we would say that point simply doesn't arise because it's dealt with at a different regulatory level by Ofcom. So the infrastructure providers, as terms of their license, governs how they have to deal with mobile network operators. They need to provide access to MNOs to their network. So that's dealt with at that level, and that the relationship between MNOs and WIPs is it's simply not contemplated that that be dealt with by the code at all. The code is seeking to deal with the relationship between landowners and, on the one hand, and operators on the other, which includes both MNOs and WIPs, and obviously cable and fibre providers as well.
Thank you.
Thank you. Yes.
Lord, my lady, 3 quick points. My learned friend was right to start his submissions yesterday with the question of ransom, because it does go to the heart of the policy behind the code, it goes deep into the implications of his analysis, and it really explains what's really going on here. Ransoms have been dealt with by the Court of Appeal in a case called Cornerstone London University, which starts on page 2311. And for your Lordship's note, the paragraph is paragraph 47, where the Deputy President is quoted and the Court of Appeal, the Master of the Rolls, Sir Terence Etherton, now Lord Etherton, Lord Justice Lewison and Lord Justice Arnold agreed that a ransom position is contrary to the principles on which the code has been designed. That's the principle expressed, which the Court of Appeal agree with in that paragraph 47. And we say, well, a ransom is where party A can obtain a high price from a negotiation because the alternative to agreement is simply not contemplatable by party B. And that's the position, we say, in relation to Queen's Oak Farm. The implications of my learned friend's analysis, which he's quite open about, leads to a ransom, because this would be a valuable site, unregulated by the code, and the negotiations about price will take place completely free of the code's limits on consideration. And it's a problem that arises because the code's been imposed on a mature network. There are 35,000 odd sites in this country. We're at least 30 years into the evolution of this type of technology. By necessity, the best position for most sites is where they are. Sites obviously have characteristics that make them good ones, high on a rooftop or hill, clean lines of vision, proximity to road transport, easy access, sufficient space for a compound. Most important, perhaps, being in the right location relative to another site. Sites with those characteristics in a mature system tend to be sites already, being used already, existing sites. So when we say operator in situ, we're talking with some of the best sites for connectivity that there are. And the implications of my learned friend's thesis is that many of those sites, at least 2,000, including Queen's Oak Farm, are closed off to the code. And worse than that, it ends in this position. And with respect to my learned friend, Mr. Pymont, his analysis of the old code wasn't correct. Let's look at it in this way. On the 27th of December 2017, the day before the code came into force, this was the position in respect of Queen's Oak Farm. The landowner could serve a notice under old code paragraph 21 for removal. It's not under the common law. There's a notice procedure under paragraph 21 of the old code. The operator could respond with a notice under old code paragraph 6 for temporary rights and or for permanent rights under the old code paragraph 5. And we looked in my submissions at the old code and saw there was a wide-ranging dispensing power over agreement, which includes, of course, a dispensing power over the need for a written agreement, which is in old code paragraph 5, subsection 7. So that was the day beforehand, before the code. It was carefully balanced. Both sides could serve notices, the operator could serve notices back. On the 29th of December 2017, the day after the new code came into force, the old code was repealed. The operator had no part of the new code apart from one part, part 6. The operator does have the benefit of part 6 simply by reason of the fact that it has apparatus on there, and the new code governs the position in relation to landowners or occupiers who want to remove apparatus. So one part of the new code, the operator had the benefit of, Part 6. The old code had been replaced, and it was quite clear that the new code wanted a smooth transition into the new code. So, for instance, when an old code paragraph 21 notice had been served already, then it would be transitioned into the new code by being treated as a new section, a new paragraph 20 notice. And that's transition provision 11. But what was the position on that date, on the 29th of December? On the Leonard Friends case, they can serve a new code paragraph 40 notice for removal of the equipment, and the operator cannot do anything. It cannot provide any response at all. It can't serve a paragraph 27 notice. It can't serve a paragraph 20 notice. It can't do anything about the paragraph 40 notice, even serve anything under paragraph 40 subsection 8, which appears to help it. It appears to be a section that says this is how you respond to a paragraph 40 notice if you're an operator and you want to keep your equipment on site. On the Learned Friends analysis, it can't even do that. So the position before the new code comes into force is finely balanced. The day after it comes into force, the operator is finished on this site, all because of paragraph 9. That cannot be the correct outcome. And the key to realising why it can't be the correct outcome is something my learned friend Mr. Parmont said, which is paragraph 9 wasn't intended to change anything. There is a perfect predecessor of paragraph 9. It's at old code paragraph 2 subsection 1. It amounts to exactly the same thing. So if paragraph 9 wasn't intended to change anything, how come, as a result of paragraph 9, the operator is in so much worse a position the day after the code comes into force? My learned friend said that his client was just the same as On Tower or as Cornerstone. Not so. Why? We are operators within the meaning of the code. We are therefore regulated by Ofcom, and that means that we have obligations to allow MNOs access to our infrastructure. APW are not operators. They've got no obligations. We have a statutory purpose. We're not free to ransom operators. There's a regulatory system. The Learned Friends client is free to ransom operators. And of course, we do very different things. We find the sites, we build the sites, we organise the utilities, we install the mast. The Learned Friends client's involvement is entirely financial. They insert themselves between the farmer or the department store or the university and the operator and then collect rents. Second point, I have to be quick on. There are many, many flaws, we say, in my learned friend Mr. Parmont's analysis, but one of them stands out that my learned friend Mr. McGee's not dealt with, and that's this. My learned friend Mr. Parmont needs to argue to address my point about keep, that a lot of the code rights seem to assume that the ECA is already on site. He says, no. The operator has to seek all relevant code rights at the start on day one. Now, first of all, if that was right, then in paragraph 3, A would be treated differently. In fact, A would probably be connected to the opening words after statutory purposes and not be a right in itself, apparently treated equally with all the other rights. A would be treated specially, which is not. Secondly, who could have designed a system like this? Because it means that the rights are frozen in time at the start. It's deeply impractical because technology is so fast-moving. Technology today is unrecognisable from what it was 10 years ago, and in 10 years it will be unrecognisable from what it is today. And obviously operators need long-term security to justify their enormous investments in these sites. If agreements are, if rights are frozen, then agreements will be shorter, much shorter, to keep operators up to speed with technological advantages. And my learned friend mentions a concern that landowners will be burdened with applications. Well, many more so if agreements are that much shorter, because the operator cannot invest for a length of time. And of course, the frozen in time thesis is completely inconsistent, as my Lord Burrows pointed out, with paragraph 11. But the mistake in the whole analysis is this, that my learned friend's whole analysis looks at this as a balance between operators and site providers. He's looking at the whole thing as a balance between the operators and the site providers. But there's not just that. There's a third party involved here, because in fact the code is about the public's access to a choice of high quality communications, and therefore patently in the middle of the term of a long agreement, if there's a technological discovery, 6G, say, it's in the public interest to have it rolled out as soon as possible. Third point, this is not Queen's Oak Farm is not a transitional provisions problem. Ashlock is whatever one says about Ashlock and transitional provisions doesn't apply in Queen's Oak Farm. The problem in Queen's Oak Farm is not transitional, it's forever. The position is that we say Schedule 2 is not the problem because of Schedule 1. Schedule 1 is the code. And Judge Cook was clearly of the view that nobody intended an operator in occupation, sending signals, providing a service, to be permanently debarred from obtaining code rights in relation to a particular site. But that's what we are. And so there's no question in Queen's Oak Farm of applying a revised code to existing arrangements. We're not seeking a new version of a tenancy at will. We want new rights. There's no question of not honouring our bargain while it lasts. We've only got a tenancy at will, and each party can terminate it immediately. There's no problem whatsoever with the transitional provisions in relation to the Queen's Oak Farm case. And our final point is just about the judgment. I just have to say, in the last minute available to me, about the judgment under appeal. I'm in a relatively unusual position as an advocate for an appellant in being able to say that that we contend that the judgment that we're appealing is unimpeachable. And the judicial context of that is also of note. At the time that Judge Cook gave judgment in June 2020, her fellow judge in the Upper Tribunal Lands Chamber, the Deputy President Martin Roger, had already accepted the proposition that an operator in situ can't acquire code rights under Part 4, and that had already been upheld by the Court of Appeal. And the Deputy President had already followed that line again in Ashlock by the time of her judgment. So it was becoming deeply entrenched. But Judge Cook said, no, a wrong turn has been taken. And she was the Law Commissioner involved in drafting the code. Her name is on the Law Commission's recommendations at page 2017. My learned friend's thesis that paragraph 9 spreads out to all other aspects of the code, enabling the outcomes in Compton Beauchamp and Ashlock, was a policy choice. But it was a policy choice that even the Law Commissioner, whose report underpinned this policy, was not aware of. And what she did in her judgment was construe this code as a whole in accordance with the clear policy objectives. She didn't construe 40 subsection 8 with a limited, narrow meaning that's not expressed. She didn't see paragraph 26 as an exception, or paragraph 27 as another exception which needed paragraph 22. She made the point in paragraph 140 of her judgment that she can't see how paragraph 22 can't have the same effect in relation to 20, for which it was written, than it has in relation to 27, if the respondent's contentions are correct. We just say this was an impeccable judgment written by a judge well informed about this code, but who did her duty in terms of the outcome, having regard to the doctrine of precedent. But your lordships are not so constrained. Your lordships have options to choose from to remedy the problems which Judge Cook identified in the Compton Beauchamp Ashlock analysis. And my lords, we say please reverse Judge Cook for the reasons she gave. As regards those problems.
Thank you very much. Well, it only remains for the court to thank counsel for their clear oral submissions, and to thank them and those who assisted them in preparing the written materials, which we will have to consider along with the oral submissions very carefully. While at the outset the Electronic Communications Code might have not struck an individual as being at the centre of his universe, it's turned into a very interesting debate, and we will take time and care to work out what we consider to be the appropriate outcome. The court will now adjourn.